Good afternoon.
Good afternoon. My name is Mark Hemvold, and I represent the appellant Afsoon Haig. I do not represent Mr. Brian Manoukian, who's pro se in this appeal. I'm going to take 7 minutes for my portion of the argument. Mr. Manoukian is going to have 5 minutes, and then I will reserve 3 minutes for rebuttal.
7, 5, and 3. Thank you, sir.
Yes. May it please the court. Ms. Haig and Mr. Manoukian were sanctions for representations they made during an underlying dispute about whether they should be required to provide a Rule 26 expert witness disclosure for Dr. Higdon. Specifically, the plaintiffs argued that they shouldn't have to provide a Rule 26 witness disclosure for him because he was a treating physician and not a retained expert witness. And also, they said they didn't know what his Rule 26 opinions were, so they
Didn't they write him a check as that said expert witness, and didn't they have a document from him that said what his opinions were?
Well, I'll
That's
address
what the
those separately.
judge found.
That is the judge said that there was a document that was created. That wasn't part of the sanctions. That was something that was disputed. That is an issue that the court can look at under Rule 13D to determine whether it believes that there was a document that existed. There is substantial evidence in the record that there was not such a document. With respect
There's
to
evidence that there was, too, and the trial court said there was.
Well, the only thing that supports that there was such a document is Dr. Higdon's recollection, which was equivocal in his deposition testimony. And what he said is, I would have typed this document, but he couldn't find anything on his word processor, any record of the document itself. And the other thing, too, is if a treating physician had typed up opinions that were critical of the defendant, that is something that you would want to preserve. There would be no reason to put that aside, especially because this type of situation would occur very frequently, where a treating physician would not be willing to testify against one of their colleagues that they see at meetings, that they count on for referrals. So that is not the case here.
What was the payment for, the check?
The payment was for the time that he spent signing off on the pre-suit certificate of good faith. And one of the key points of that, just because he was willing to sign off on that, doesn't mean that he's willing to serve as an expert in the case. And I do want to, one thing you didn't mention, but I do want to specifically address, there was also an email from Ms. Haig where she said, we want to retain you as an expert witness. We would have loved that. Any plaintiff's lawyer would have loved to retain a treating physician as an expert witness. But the reality is, most treating physicians are not willing to do that. And here, Mr. Higdon testified he never agreed to serve as a retained expert witness. He was not willing to serve as an expert witness, even though that's something that was wanted. It was not something that actually happened in this case. So whenever they represented that we have not retained this person, we cannot give you a Rule 26 disclosure for this person, that was accurate. And it was a legitimate concern as well. The other aspect of the representations that were challenged is they said, we don't know what his opinions are. And remember, this is in the context of a dispute about whether they should be forced to give a Rule 26 disclosure. They didn't know what the Rule 26 opinions were. And it would have actually been much more of a breach, much more of a serious issue if they did what the defendants were trying to get them to do. If they said, you know what, we had this conversation with this physician a year or two ago, we're going to give you a Rule 26 disclosure. This guy is our expert witness, and we think he's going to say the defendant violated the standard of care. We think he's going to say that this caused this injury. If they had done that, and then the deposition happens and the physician says, I don't want to testify to anything, like he actually did, that would have been far more sanctionable. And in fact, we've cited several cases that really illustrate that point with respect to those sanctions.
So your client did meet with Dr. Higdon and discuss Dr. Higdon's professional opinion about the care, but it's your position that Dr. Higdon had not agreed to be an expert witness for testifying at a trial.
That's right, and there's some important distinctions between signing off on a certificate of good faith and agreeing to provide Rule 26 opinions. First is, substantively, much less is required, and there's a string of decisions in the Court of Appeals on that point. All you have to say is, there's a good faith basis for this case. That's all you have to say in order to sign off a certificate of good faith. You don't have to have detailed expert opinions, and that type of opinion is not enough for a Rule 26 expert disclosure. And the other thing too is that whenever a physician, treating physician especially, agrees to sign off on the certificate of good faith, it's confidential. That component of the discussion is not something that is disclosed.
Well, what about when your client sent an email to the doctor saying, I will be sending the records and payment in the next 7 to 10 days so that we can retain Dr. Higdon as an expert?
That's right, and she wanted to retain him as an expert. She would have loved that, but he wasn't willing to do that.
Well, he took $1,500. That was his expert fee, wasn't it?
He did, and treating physicians don't testify for free. They don't meet for free. They charge for their time. And one of the cases that we cited, I think it's the Hall versus Sykes case.
That's right, but didn't he say that was their fee, their expert fee?
Well, that was what's written on the memo of the check, but that's not a statement by either of the appellants here or by Dr. Higdon. And Dr. Higdon testified that he never considered that himself as being a retained witness. One other point is, in the context of a Rule 26 disclosure, a retained witness is a term of art. In fact, some of the case law talks about retained versus non-retained witnesses. And the idea is, when you retain someone, then you have to provide disclosure for them. And the idea is you have access to them. Part of the rationale for why you don't have to provide a explanation or any notice for what a treating physician is going to say is because you don't have access to them. And I just want to emphasize on the merits issue, these cases that talk about how plaintiffs have gotten sanctioned for giving Rule 26 disclosures based on a conversation, but because they didn't confirm. One instance, the one case that we cited, the Nancaro case, the plaintiffs had provided Rule 26 disclosure, and then the defendant settled. And the defendant found out later, wait, that treating physician wasn't actually going to say what they disclosed. They sued the plaintiff's lawyers, they sued the plaintiffs for fraudulent inducement based on the settlement. And the court denied summary judgment. That case went forward against them. So that is the type of risk that these plaintiffs' lawyers were avoiding whenever they said, we don't know exactly what he's going to testify to whenever he is deposed.
All right, thank you, Mr. Himmelvold. Good afternoon.
Good afternoon. My name is Brian Manukian, and I'm here on behalf of myself. Judge Bennett, I want to address a couple of your questions before I get started. In these healthcare liability cases, which I've tried for years, it was the bulk of my practice. I defended them for a number of years. I prosecuted them for a number of years. I've recovered tens of millions of dollars in these cases. This was my bread and butter. The reality is, before you can file a case under the Healthcare Liability Act, as you all well know, you have to go to a physician who's either licensed in Tennessee or a contiguous state, and this is their specialty, and say, look, this is what we intend to sue about. Take a look at the records and tell us, do we have a good faith basis for the suit? And the legislature has determined that the reason for that is to knock out frivolous suits. I mean, there's an entire legislative history about how this would bring down insurance and healthcare costs, right? So before you can file any of these suits, you have to go to a physician and ask them for a good faith certificate. They don't do it for free. I wish they did. In most cases, it's $500 an hour. They will take a look at it. In this case, Dr. Kent Higdon had seen the plaintiff following the breast surgery that led to the malpractice. He knew about what occurred, right? And so he was a natural choice to be a good faith certificate physician to sign off on it. He's willing to do it because it's confidential. He wasn't willing to be a Rule 26 expert because he knows Dr. John David Rosdeutscher. He testified to that. They run in the same circles. They go to breakfasts together. They see each other in the operating room at Vanderbilt. That is so standard as to almost be the rule in Tennessee. In my experience, physicians in Tennessee will not testify against one another openly as Rule 26 disclosed experts. They will frequently and confidentially serve as your good faith certificate expert because their buddy's not going to find out that they did that. They can get paid for it. They can sign off on the certificate, but their identity is never disclosed. That's precisely what occurred in this case. Dr. Higdon was willing to serve as a good faith certificate expert, but he was never going to testify in open court or even allow Dr. Rosdeutscher to know that he was the man behind that good faith certificate. So in this healthcare liability case, we had a scheduling order, as you do in most cases, right out at the gates, right? And those scheduling orders say, we'll go through fact witness discovery and we'll go through Rule 26 discovery. I noticed Kent Higdon's deposition as a fact witness right out of the gate because I wanted to know what he would say. Could I get him to opine on the standard of care on the record? Could I get him to say that, yes, this gentleman caused an injury? I didn't know if he would do it. I suspected that he wouldn't. But if you can get a treating physician to also serve as a Rule 26 expert, it's game over in these cases. They're not seen as hired guns. It's incredible leverage to settle the case, right? And so Mr. Klein, being a very good lawyer, started filing motions saying, before Dr. Higdon testifies, we want a Rule 26 disclosure. I don't want to walk into this deposition blind and find out he's going to say a lot of things about my client. My response was, I don't know what he's going to say as a Rule 26 expert. He may decline to serve as it. I suspect that he would. And that's the crux here, and that's what you must understand. The motions to which I was making the representation, I don't know what he's going to say, were motions to disclose as a Rule 26 expert. They were not, and this is important, I underline this, they were not motions to disclose your good faith expert, because there is no such thing. The statute says a good faith expert may only ever be discovered if they file a motion for summary judgment and I do not respond with competent expert testimony. Because in such a case, there is an assumption that maybe you didn't have a good faith expert. So what I was being asked over and over was to disclose the Rule 26 opinions of Dr. Higdon, and my response repeatedly was, let's take his deposition and ask him what they are. I'll be happy to do it once we ask him. And that's what we did.
Now, the trial judge said that he and your co-counsel, Dr. Higgins and your co-counsel had discussed the case, and he had given opinions and sort of attributed knowledge of one lawyer to the other and said you both knew what he would testify to and you should have disclosed it.
I didn't. I knew that he believed that there was a good faith basis for filing a lawsuit, and I wish that he would testify as a Rule 26 expert. Of course you want him to do that. I actually noticed his deposition and asked him those questions, and Mr. Klein shut the deposition down. That's how we ended up back there, right? I wanted to know if he would do it. So we took that deposition to find out whether or not I was being fair with the court when I said, I don't even know if he's going to do this. The question was, by Mr. Klein, are you serving as an expert witness for any party in the case? The answer, no. Are you planning to? No, sir. Are you going to offer any opinions on the standard of care? No, sir. Are you going to offer any opinions on causation? No, sir. These are all block quoted in the brief. That's what I want you to understand. There was no intent to be dishonest or mislead anyone. In fact, I was trying to set this as a fact witness deposition to force this doctor to say, yes, I think he breached the standard of care. Yes, I think he caused the injury, right? But I can't compel him to do it. There's case law in Tennessee that, in fact, Mr. Klein just had a big win at the Tennessee Supreme Court in the last 30 days about how you can't compel a treating physician to give expert opinions. And so, yes, while I knew that he was happy to serve confidentially as a good faith certificate, the motion and the context of all of this was Mr. Manukian disclose his Rule 26 expert opinions. I didn't know that he would give them. I didn't know what they would be with any specificity. And I did know that if I came out and said, he's going to claim that the defendant cut the blood supply to the nipple. He's going to claim that the breast became necrotic. If I said those things, and then Kent Higdon, who I didn't represent, he was represented by Daryl Townsend. If he then showed up and said, I'm not saying any of those things, I decline to serve.
All right.
That would be sanctionable.
All right. Thank you, Mr. Manukian.
Thank you all.
We'll now hear from the appellee. Good afternoon.
Good afternoon, Your Honors. Matt Klein for the appellees, Dr. Rosdeutscher and Cumberland Plastic Surgery. Given the time constraints of our forum here, I do want to use my time effectively and efficiently. So if there are areas the court would like for me to address out of the gate, I'm happy to do that.
Well, I'd like to know if there was any, the judge's order on the sanctions was just an order. It didn't refer to any hearings or anything like that. Were there any hearings on the amounts and justifiability of the attorney's fees that were awarded?
Are you referencing the amount of the attorney's fees? We had, I think, 5 hearings on the sanctions issues.
Yes, but did you discuss the amounts of the money that were to be used for sanctions? And, you supplied the court, apparently, a list of the charges, how much which attorney spent on what thing. And did the other side, Mr. Manukian and others, get to look at those and comment on them or anything like that?
So, to answer your question directly, there was no specific hearing on the amount of attorney's fees entered.
Okay.
At the final hearing on the sanctions issues, the trial court ordered the parties to submit proposed orders and any documentation supporting any request for attorney's fees. At that hearing, there was no request from Ms. Haig or Mr. Manukian to have another hearing on attorney's fees. In the days that followed, before anything was submitted, there was no request for Mr. Manukian or Ms. Haig to have a separate hearing on attorney's fees. After we filed a declaration from my partner, Dixie Cooper, which set forth our hourly rate, our qualifications, how many hours we had spent on the case, that was provided to opposing counsel. There was no request for a separate hearing. There was no objection by the appellants to the fact that there had not been a hearing. In fact, to this day, there has been no specific objection to the amount or the reasonableness of the rate. And so we would submit that those arguments were waived because they were not raised in the trial court. And as to the amount or the reasonableness, that's been waived on appeal. There's been no argument that the number of hours we spent litigating these sanctions issues over 2 years, at a point when the underlying case had been dismissed, the only issues remaining were the sanctions issues. There were over 100 filings that were done on the sanctions issues alone, 5 hearings, a second deposition of Dr. Higdon, written discovery subpoenas.
So your position is to their claim that they had no opportunity to challenge or evaluate your attorney's fee requests, that they didn't ask for a hearing and they never made an objection to the process or anything?
That's correct. And there's case law that has affirmed awards of attorney's fees under situations where there is not a separate hearing on the specific amount or reasonableness of fees. And so that's what we would rely on.
All right, let me ask you about the basis for justifying the sanction. Dr. Higdon testified that he never agreed to be the expert witness. How do we then conclude that Mr. Manukian or Ms. Haig misrepresented or hid the fact that he was to be an expert witness?
Well, I would respectfully submit that that's a mischaracterization of Dr. Higdon's testimony.
Okay.
That testimony from Dr. Higdon came in 2021, 2 years after his original deposition and 3 years after he had been retained to be the certificate of good faith expert. Because he did testify, I did agree to review the case. I did agree to provide opinion there was a good faith basis for the claim. And regardless of how you slice it, a certificate of good faith expert is still an expert. And so the representation that Dr. Higdon had not been retained as an expert was a false representation. The representation to the trial court in November of 2019, repeatedly by Mr. Manukian, was, I have not retained him as an expert. But they had, and we know they had, because we have this email from Ms. Haig that has never been rebutted that said, March of 2018, we would like to retain Dr. Higdon as an expert. And then they sent him a check, $1,500 for expert review.
So how does the statute about good faith certificates then play in on this? How do you reconcile the statute and the identity of a good faith consultation and this ability to get them to disclose, party to disclose this person?
So there's a couple points on that issue, Your Honor. First of all, the statute does not render the identity of the certificate of good faith witness privileged. It renders one thing privileged and one thing only privileged, and that is the signed statement from the expert. That's the only thing. And perhaps more importantly, I don't know that there's a privilege in this state that allows an attorney for a party to go lie to the court. There's a crime fraud exception to the attorney-client privilege. There's the Reynolds versus Gray medical investors case that says the non-waivable quality improvement privilege cannot be used to protect fraud. So I would respectfully submit that Mr. Mnookin and Ms. Haig could have asserted privilege and said, we're not going to tell you whether Dr. Higdon has been retained as an expert. That's not what they did. They said, we have not retained him as an expert. And so that representation to the court, which was later learned to be false, is certainly sanctionable. And so that's...
Wasn't Dr. Higdon the treating physician?
He was a treating physician, that's correct. But
And you can't force a treating physician to give expert testimony on standard of care, as you know in your case, it came out just recently. So how did we distinguish these what now appear to be subtle lines?
well, in this instance, a treating physician is an ordinary witness, right? That's the general law.
And
we know
isn't that what he was originally, Dr. Higdon?
before he's contacted by plaintiff's counsel.
Yes.
Yes.
Okay.
The case law, I think, reflects that they're an ordinary witness. I can send an interrogatory that says, hey, what does this ordinary witness know, plaintiff? What have you learned from him? And I did that. I sent a request that said, do you know of any standard of care causation opinions from treating physicians? And these opinions were not disclosed in there.
Well, they had to disclose the medical records, and they had to give you a release to allow you to get them directly from Dr. Higdon.
That's true. My point being, when I sent that interrogatory that said, tell me if you know any treaters' opinions, they didn't disclose these, right? So a treating physician may not be compelled to provide opinions, but once an attorney knows opinions from a treater, they cannot pretend they don't know those opinions.
Even, you know, granted, this was not really my practice area, but in the commercial context, sometimes we would have consulting experts where we would talk to a witness, say, we're hiring you as a law firm to advise us and give your expert opinion on it. And that might end up being a retained expert. Now, I'm imagining that is true in the healthcare liability action context as well. And had they done that and you get that opinion, you go, oh, well, we don't really care for that opinion very much. You don't have to disclose that, do you?
That I agree with, Your Honor, that there are consulting experts that can be used in this context. Rule 26 makes consulting expert opinions privileged. And what does a party have to do under Rule 26 when they assert a privilege? They have to make the claim specifically so that it can be evaluated by the opposing party. What we never had here was an assertion that Dr. Higdon was a consulting expert. That's the issue.
Okay, so let me ask you this, and when I look at this, I'm sort of confused about how this escalated into what it escalated into, and I'm hoping you can clear this up for me. If I had a party that said, we don't have an expert or can't identify the expert, and then suddenly they show up and start asking expert opinions, I would run to court right away and say, Your Honor, this motion in limine, this gets excluded, don't get to hear this, we don't get to ask it, and in fact, the deposition was stopped just because that question seems to appropriately so, because not disclosed. It typically stops there, though. But here it seemed to
Snowball.
Snowball. What started the snowball? How did it start rolling?
Well, in our view, it's what we always thought was occurring was Mr. Mnookin was doing exactly what he said. If I can get a treater to criticize a defendant, that's a powerful piece of evidence. And so we believe they did not want to reveal the fact that they had hired Dr. Higdon, paid him money, sent him records from Dr. Rosdeutscher, because that makes him more than just a treater. That makes him a hired expert, and it brings him into the realm of not as credible as a neutral treating physician. And so that was our view of what was happening. I can't speak for why the appellants did what they did, but we go into that hearing after the first deposition. I file a motion to say, hey, standard of care opinions under Buckner need to be disclosed because it's the witness is relying more than just on their actor or viewer observations. Dr. Higdon did not review or did not observe any treatment of Dr. Rosdeutscher. These need to be disclosed. Mr. Manukian then says, I haven't retained this guy as an expert. I don't know his opinion, so I can't give a Rule 26 disclosure. Well, we know from Dr. Higdon's deposition later, they did know his opinions because he told them. And so Judge Jones, what does Judge Jones do? He sanctions us for filing the motion. So then we send a subpoena to Dr. Higdon, say, hey, produce any documents you have with this law firm. And we realize that these representations to the court were not true. So we file a motion for sanctions. And frankly, what I expected or hoped would occur would be the appellants come in and say, we made a mistake. You know, we should have disclosed this. We should have asserted privilege over it. That's not what happened. We got the continued representation. We don't know his opinions. We haven't retained him.
Let me ask you this other scenario, and I want to just try to understand the context of what's going on here. Why wouldn't the response not be a motion for sanction at that point, but rather a motion for summary judgment? They don't have an expert. And, you know, normally in med mal cases, the limited experience granted that I had, and it was always sort of a race for the defendant to come in with the defendant's own affidavit saying, met the standard of care, we win. You know, you don't have an expert.
There was still some additional time when they could find another expert.
Okay.
And then they non-suited the case.
Okay.
They non-suited the case 2 days after the hearing on the motion for sanctions. Okay. And that was actually prompted by Judge Jones saying, no, plaintiff, you still need to disclose your experts by the deadline, which is coming up in a couple days. Yeah. So they non-suited. That's why. And also, we felt an obligation as officers of the court to point out to the court, trial court, there were false representations made to you. And that's not appropriate, and it shouldn't happen. Under no circumstances should a lawyer be able to come into court, claim they don't know opinions from a treating physician that they've talked to and they know their opinions. And so that was something that we felt was important to do. Are there questions about other aspects of the?
Well, question, if I'm representing a plaintiff in a healthcare liability matter, and my client has seen 5 physicians over the last 3 years, I'm not under an obligation to reveal all 5 of them as a Rule 26 expert witness if I don't intend to call them as a witness.
I agree with that.
No.
I agree with that. But I also don't think that you can tell the judge, I don't know Dr. Smith's opinions if Dr. Smith has told you his opinions. Mm-hmm. And I don't think you can represent to the court that I haven't hired Dr. Smith as an expert if you paid him money and sent him outside records. That's really what this is about.
And your view is that even though the attorneys did not have a written statement from Dr. Higdon, they had an oral declaration from him, and that was sufficient. Is that right?
I'm glad you brought that up, Your Honor. The May 10th, 2018 meeting, Dr. Higdon testified there were 2 documents at that meeting. There was one document prepared by Ms. Haig that he signed. That, we know from another order from Judge Jones, was the certificate of good faith. Dr. Higdon said there was a second document that I wrote that also set forth my opinions about the care Dr. Rosdeutscher provided. I gave that to Ms. Haig. I did not keep a copy of it. One of those 2 documents was produced to the court. We know that one of those documents existed and was not actually produced to the court until he entered 3 separate orders. They violated 2 orders. Ms. Haig violated 2 orders before finally producing it. So the suggestion that neither of these documents exist is demonstrably incorrect. There is conclusive evidence that one of the 2 existed. May I finish?
Yeah, please do.
And we also know there is unrebutted evidence from Dr. Higdon that the second document existed, because there is no evidence from Ms. Haig, no testimony from her, no admissible evidence to rebut that testimony from Dr. Higdon that the second document existed, in addition to his oral statements.
Is it possible that the second missing document, if it exists, was a different version of a certificate of good faith?
From the testimony from Dr. Higdon, it seems that is unlikely, because I've never seen the certificate of good faith document. It was provided to the court for in-camera review. It has never been provided to us. So I only know what Judge Jones said about it. and what little Dr. Higdon said about it in his deposition. But what he said about the document he prepared is that it contained his opinions on standard of care and causation. And that's in his 2021 deposition. Unless the court has questions, we would ask the court to affirm.
All right, thank you,
Your Honor.
Mr. Klein. Mr. Hammervold?
I'm going to address the
I'm
rebuttal
sorry,
here
Mr. Manookian.
because there are a few things that I was personally involved in. I took the deposition where Dr. Higdon did not unambiguously say that there was a second document. He said he thought there might have been a second document, and under cross-examination withdrew that, walked that back significantly. There wasn't a second document. There was a document that he signed that was a certificate of good faith, and that was it. Judge Bennett, you started by asking, did the appellants have an opportunity to rebut or cross-examine the attorney's fees? The answer to that is expressly no. The appellees first filed their declarations and requests for attorney's fees along with the billing records on April 23rd, 2021. That's in the technical record at 793. The local rules would have given us until May 3rd, 2021 to file a response. The trial court did not wait until then to enter their order awarding all of the attorney's fees that had been asked for. The trial court entered its order on April 28th, 2021. That's in the technical record at 893. And so he's correct. They were filed with the court. The court didn't even give us the 5 days that are required under the local rules to file the response or the objection. Not only did we not get the 5 days, we never saw the attorney's fees or the broken out billables. They were filed under seal with the court. They're still under seal with the court. If this court recalls, and it's part of my brief, they were brought up on the appellate record under seal, and Judge Jones ordered this appellate court to reseal them so that we couldn't see them. To this day, I've not seen the billable records for which I've been charged or had an opportunity to cross-examine them or question whether they were appropriate. So the representation to the contrary is just absolutely false. They were submitted for the first time on April 23rd. The court entered its order on April 28th before the 5 days to object. Not only did I not waive that, I filed my notice of appeal on April 28th, the very day the court entered its order granting those attorney's fees.
So you were never served with a copy of those fees or anything?
To this
They
day.
just went to the court and you never saw them?
Exactly. They
Okay.
were filed under seal to this day. Mr. Klein spoke about an interrogatory where he said we should have disclosed Dr. Higdon. And I'd like to hand it up to the court if I can through the marshal or just directly.
Is it in the record?
It is in the record. It's record
You can
volume
identify.
2 at 216. The interrogatory specifically asks, quote, experts consistent with Tennessee Rule of Procedure 26024. And Judge McBrayer, you're exactly right. This is absolutely analogous to a consulting expert prior to filing suit. That's exactly what this is. And so once again, I would,
Except this is a treating physician.
this is a treating physician, which I think
can't
militates
come-
even further in our
Which
favor.
can't be segregated out as a consulting expert.
But in the sense, I can't compel him for his testimony.
Correct.
And so the other thing that I think is very important is the context of all of this. The appellees continue want to talk about an expert, an expert, an expert. The context was disclose a Rule 26 expert. That was the motion, and those were the 5 hearings. That motion is in Technical Record Volume 2 at 111. When I am saying I can't give you his opinions, it's because that answer, I can't give you the opinions, the question was for a Rule 26 expert. It was a specific question calling for a specific answer. There was no attempt to mislead anyone. To this day, they want us to disclose Dr. Higdon as an expert. He refuses to do it. That's really the end of the matter. I'm not sure if Judge Jones thought that Dr. Higdon would get to the deposition and say, oh yeah, these guys retained me as a Rule 26 expert. They paid me $20,000. $1,500 is a middling sum for an expert.
All right, thank you. Thank you, Mr. Manookian.
Thank you.
And Mr. Hammervold and Mr. Klein, thank all 3 of you for your arguments. We'll take the matter under advisement.